What can I do?
Len, I can't hear you. Gotta unmute yourself.
Do you have everything you need?
I will apologize in advance. I have my granddaughter here, so she'll probably end up in my lap.
Were you able to get it to us?
Okay, we're just waiting for Stephen to hook up.
Okay.
I'm in bed. He can't come. I can send you the link by your email that Alana sent her. Does that work? Yeah, okay, I'll do that.
Any luck? I'm on, but I was not able to click on the link of the agenda and to sign on. Valerie went in through some other convoluted method.
Leonard?
Yes.
The link led to a Zoom platform, but when that platform timed out, it went to, you had to go in through the browser. Who are you talking to now?
I'm talking to Stephen to see if he can get on.
Oh, I sent him a link by
He's on
email
right now.
and to his text phone.
Okay.
Did he get it?
Are you on, Steve? No, I can't see you, but you're probably there somewhere.
Did you get the text?
He's on. He's just connecting to audio.
Oh, good.
How do we get rid of this? The town adults thing. I don't have full faces.
Ask Alana because I don't know how to do it.
What's the matter?
All right.
He's trying to make the,
The town of New Paltz logo is
Okay.
is
So you have to go to the top right corner. There's a little button that says view on it.
oh,
Click view and make sure it's checked off on gallery and not speaker.
there's view. There it is. Gallery. There you go. There you go. All right. Thank you.
okay. I guess we're ready to start. 7 minutes late. I'd like to welcome everyone to the February 10th meeting, Zoom meeting of the ZBA. Entertain a motion to open the meeting, please.
I'll move.
Thank you, John. Second? I'll
Move.
second.
Third.
All those in favor?
Aye.
Aye.
Okay, meeting opened. First thing we'll do is we'll take the attendance. I see that Catherine is here. I'm here. John Gatto's here. I saw Catherine Fuller. Where are you? You're Catherine's here. Stephen, are you there?
Yes.
Okay, and Amy's here. So everyone is here. Okay, good. That's good to know. I guess under first thing is the administrative business. If everyone had a chance to look at the January 13th minutes, did anyone find any corrections?
No, they were very good minutes. Thank you.
Yes, I found nothing to correct. Okay, I entertain a motion to approve the minutes of the January 13th.
So move.
All those in favor signify by aye.
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 Aye. Minutes
Aye.
approved. Next thing is the quorum check for our March meeting, which is the 10th, March 10th. I will be there.
I'll be
Yes.
there.
Amy will be
Yes.
here. John will be here. Catherine?
Yes.
Stephen?
Yes.
Okay, looks like we'll have a full house. I also would like to include in the attendance, Stacy DeLaray, our building inspector, is here, and Joseph Moriello, our attorney, is here also. Okay, at this point in time, I would like to open the floor for public comments. Please keep in mind, if you wish to make comments, that they are not part of a public hearing. Therefore, they are not record to be recorded with that public hearing. So if you have comments to make about a particular item on the agenda, I would suggest that you wait to speak until the public hearing of that time. It is not mandatory that you do that, but for it to be considered in the consideration to accept or to deny that item on the agenda for its particular variance, I would recommend waiting until a particular time. So I entertain a motion to open the public comment time.
Move to
do.
open.
Okay.
Okay, John, second. All those in favor by aye?
Aye.
Aye.
Okay, anyone there on the floor for public comments?
I am here speaking for, my name is Susan Stessman, and I am speaking, it may be on the agenda. I couldn't find it, so I apologize, but I can't stay too long. So I'd like to read a letter that's written by Susan Blickstein. Is that okay now?
You are reading a letter for Susan Blickstein?
Yes, she was not able to read the letter. So I was asked if I could read this letter for her.
Joe, is that acceptable that one person reads a letter for another person?
Is it a letter that has been sent by the writer on a matter that's going to come up for a public hearing?
It's on the Trans Hudson.
The public hearing for Trans Hudson is not at this meeting. It will be scheduled for the March meeting.
Right, I would, see, the problem is doing this at a public comment period where there's going to be a public hearing on a pending application. It gives information to the board that, while it's true, it's not going to be part of the record, unless it's submitted as part of the record in the public hearing, but the board can't unhear it. And in fairness to the applicant, I think if this is a letter that someone feels that they want to put into the record at the conduct of the public hearing, certainly the letter can be submitted or read into the record at that time of the public hearing. But it is somewhat unfair to the applicant to have the board hearing argument outside of a public hearing setting where they have no opportunity to either hear or respond. But I certainly would invite Susan or the writer to submit that at the time of the public hearing, which I'm expecting will probably be set by the board at tonight's meeting for a future meeting.
Okay.
I think
if
it would be
that's-
really more proper that that letter come before the board in advance of and at the time of the public hearing.
Well, I was hoping to be able to read it tonight, but if you're saying that I shouldn't read it tonight and would it carry more weight at the next meeting? Is that what you're saying?
I certainly, if it's submitted at the public hearing, it becomes part of the record of the public hearing itself, which the board must take into account when it renders its final decision. So not that it's of perhaps more weight, but certainly if the writer feels that it is important enough, they should certainly submit that letter to the board to be considered as part of the record made at the public hearing.
Okay.
Does that help, Susan? I want to be
guess.
certain the writer gets an opportunity to say or
She
submit
submitted
what it
this
is
letter
that they want
already.
to submit at the correct time.
She
Okay.
submitted this letter via email, right?
I assume so.
Yeah, I think she submitted this already.
Yes.
And I have it. Yeah. And
Oh.
I passed it along.
All right, so then the board has it and the board will have it in its packet at the time of the public hearing.
Okay, so then I would read it at the next meeting then, when it's the public meeting. Or if she's able to, then she could read it.
Or
Correct?
if she's able to, she could. Yes, ma'am.
Okay. All right. Thank you
Yep.
very much.
Thank you.
Okay. Okay. Good night.
Good night.
Good night.
Anyone else for comments for the public hearing?
Yes.
We have two people. Daniel's hand was up first.
Okay, thank you. I'll be very brief. I did submit a letter, so I'm not going to read it. I'm just going to make a very brief comment, and I realize that tonight is not-
Daniel, please state your name. Most of us know who you are, but there may be someone else signed on who does not know who you are.
Of course, I apologize, Len. My name is Daniel Schneidman. I live in the town of New Paltz. I'm going to make a very brief comment tonight, even though I realize it's not the public hearing, the formal public hearing. I won't elaborate, but I hope the ZBA will discuss whether the drive-through variance request, and this is also in regard to Trans Hudson BFB's variance request, whether the drive-through variance request specifically should instead be considered a use variance. I also hope that the ZBA will consider whether the 2017 negative declaration from the planning board actually authorizes the project before you now, or whether the seeker review needs to be reopened, given the significant changes that have occurred in the interim. But as far as the variance requests that will be presented later, I don't think the applicant has adequately supported their claim that there would be little rental interest in the second story space required by the MSMU zone. Second story rental space exists throughout New Paltz and is commonly used for offices, studios, and other uses. The applicant seems to be narrowly insistent on having a retail use in this second floor space, and even more specifically on renting to a national retailer. National retailers, they assert, will not be interested in second floor rental space, leaving the applicant no choice but to rent to, quote, lower quality retailers who will pay less rent, unquote. This is a derisive characterization of local businesses in a community that has time and again emphasized their preference for independent, locally owned, non-chain businesses. While the applicant should be able to determine who the second floor tenant is, an arbitrary commitment to only renting to national retailers is not adequate grounds to justify the requested variance. Concerning the drive-through, again, very briefly, I hope the ZBA will consider how permitting a drive-through restaurant at this location will make an already bad traffic situation at the Route 299 Puck Corners Road intersection significantly worse. I'm sure all of us have experienced long wait times at this intersection. And as I described in my letter, the applicant's own 2019 traffic study projected that westbound wait times on Route 299 would get more than twice as long as 2019 levels if their project was to be built. Crucially, this projection did not factor in a drive-through restaurant, which was at that point not part of the proposal. The drive-through restaurant would create substantially more traffic volume than a non-drive-through restaurant, resulting in longer waits at the intersection for New Paltz residents, a major negative impact on the neighborhood. The applicant should be encouraged to minimize traffic impacts, not exacerbate them. Finally, the joint town-village bike pedestrian committee has already called the proposed driveway on Route 299 a quote, major safety risk because cars entering the site would need to pass two-way bike and pedestrian traffic on the Empire State Trail. Granting a drive-through restaurant use at this site would substantially increase the volume of traffic crossing this dangerous proposed driveway. The proposed Empire State Trail connector path, which the ZBA previously studied, which will cut through the site, mitigate this danger only for Empire State Trail users traveling from the east to the north, but would not impact many other Empire State Trail users who would still need to cross the proposed driveway. As the ZBA is aware, the town board, in close consultation with legal counsel, meticulously crafted a resolution justifying their unanimous decision to deny waivers sought by the applicant for the drive-through restaurant and second-story exemption. While the ZBA is its own venue with its own criteria, I hope that you will take a careful look at the town board's resolution as the same flaws present in the applicant's request then remain intact in what is before you now. Thank you very much.
Thank you. Anyone else have any comments during the public speaking time? Is that correct?
Janelle Piotr.
Janelle Piata? You're next.
Thank you. Yes, I'm Janelle Piotr, resident of the town of New Paltz. As a coordinator of New Paltz Climate Smart Task Force, I'm speaking tonight regarding the Trans-Hudson proposal. I realize this is not a public hearing, but I just want to give context and food for thought as you consider this waiver request. I could talk about the town's pledge and certification as a climate smart community whose main goal is to reduce greenhouse gas emissions, but instead tonight I would like to focus on the question as to the need for a drive-through. A recent article actually—
Joe, just 1 second. Joe, Mr. Moriello.
And I apologize for kind of jumping in here, but in fairness to the first requester who wanted to read in a letter, again, I'm going to caution the speakers that if you want public comment and you're going to take, make particular arguments or issues with respect to the application, the proper place is at the public hearing at which all parties are entitled to be heard. I think if these comments go beyond that, or they amount to essentially the equivalent of the same comments that are going to be made at the public hearing, they really do not rightfully belong in an open public comment period. Public comment is designed for something other than going to the record with respect to pending applications. So Janelle, if there's a letter,
unstable and I'm
if there is a letter that you have or positions that you want the board to hear, the proper place for those is at the public hearing, in my view. Not doing it here as part of a public comment. It really doesn't serve any purpose. It's unfair to the applicant, in my view.
I will defer to your advice. I guess I was just picking up that the first request was based on reading somebody else's letter. This was my own and
Right.
not submitted, but
Yeah, well, my concern was not that it happened to be, yeah. My concern was not that it was someone else's letter being read. that's fine. And your own position here,
I
but I
understand
think
it.
properly that should be done at the public hearing, and you are certainly invited to do that, to submit to the board in advance of that public hearing, writing if you have it, and to make the information in that writing heard at the time of the public hearing when all parties have an opportunity to consider what's in it and respond perhaps if they choose to.
Thank you.
I'm
Okay,
not
I
trying to
understood. It
curtail
was-
public hearing, but I
but I
am trying to protect the record in this matter with respect to a particular applicant.
Kitty?
You. I sat for 12 years at town board meetings with Joe Moriello, and we listened to hours of public comment on subjects that were or were not before us as public hearings. And my understanding about public comment is that the public is encouraged to talk about any subject they wish, and usually it is an item that is on a forthcoming agenda, with the understanding that whatever we say during public comment, if it's not part of a public hearing, isn't going to be part of the record of that issue. So I guess basically what I'm saying is that I think public comment, it should be a time where people can talk about whatever issue they need to talk about, with the understanding that it's only at a public hearing when those comments will be a part of the official record. Having said that, the only thing I want to bring to the ZBA's attention tonight is that later on, when you review the application letter from Trans Hudson, there is a misstatement that the Village of New Paltz has indicated support for supplying water and sewer. And actually at tonight's village board meeting, they are going to be, it's on the agenda to discuss under what conditions they would consider offering water and sewer to this project. So that is an error in the application letter that you will be discussing tonight.
Received from Sticky New Paltz.
Amy,
So-
you're next. Thank you, Chris, Kitty. Amy, you're next.
I'd just like to say that to Daniel, Kitty, Susan, Janelle, that have mercy on us. You're reading letters to us that we're going to later read when they're actually in print. We will remember that your points much better if, instead of reading us a letter now, you do us the courtesy of sending the letter. You've had time to edit it. We've had time to look it over, formulate any questions we might have, and we could do that so much better at the public hearing.
Thank you. Anyone else have anything else for the public comments? Motion to close the public comment time.
Oh, so move.
Thank you. All those signify by aye.
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 Public comment closed. Okay, next item we move to are public hearings. Alana,
Yes.
have you received the affidavit from Mr. Rotolo with regard to application?
No.
No, you have not. I guess at this point, I would speak to Mr. Moriello. This is the second time that we have not received the affidavit from Mr. Rotolo. Any recommendations as to what we should do to move forward?
May I please submit the reasons, which I did already in writing, but may I please submit the reasons as to why there
No,
was no
no, you may
affidavit
not.
sent?
Not now. I would like to hear what our attorney has to say first.
Okay,
Well, yeah, it was my understanding that the agent for the applicant, Mr. Rotolo, would be in attendance at least by phone. And I just this evening before the meeting saw a recent submission by Mr. Rotolo consisting of, I think, about 44 pages, where he voiced his position with respect to issues such as the public hearing, the setting of the public hearing, statute of limitations, and the relief requested. If Mr. Rotolo has included in that submission everything that he wants to include, then I don't know that the board needs to hear it again. There is no public hearing. There's no public hearing opened, and the public hearing cannot be opened unless the notice provisions have been complied with. And
Okay, I have not included everything. There is one more item that I would like to add to that list of items, and it is New York State Town Law 267. The law is titled Zoning Board of Appeals, and paragraph 6 specifically sets forth that any member of the board who was appointed at the time of when the application was pending is not allowed to vote on the matter. So the vote that was taken on the 9th of December with respect to a public hearing did not have a quorum. The reason why it did not have a quorum was because Stephen Esposito correctly recused himself because he has done work at the house, and two members, I believe it's Amy and someone else, I don't know the other person's name, they were appointed at a time when the application was already pending. So the vote that was taken on the 9th of December to have a public hearing was a vote that had no quorum because it had three people. Two people were not supposed to vote on it because they were appointed when the application was pending. Steve recused himself. That is not in the material that I sent, and therefore I wanted to add that to the record. Along with what the New York State Secretary of State qualifies as a special use permit, which it identifies it as a purely administrative function, requiring the standards be set out in the zoning law to guide the Board of Appeals in passing upon applications of such permits. So, for all of those reasons, along with Town Law 267, which is Zoning Board of Appeals, paragraph 6, which states no additional member shall take part in the consideration of any matter for which an application was on file with the Board of Appeals at the time of his or her appointment. That is how the last sentence in paragraph 6 of the New York State Town Law 267, titled Zoning Board of Appeals, that is how that last sentence reads.
I would just ask Mr. Rotolo, do you intend to send in then an additional submission with respect to that point?
If you would like me to, sir, certainly.
Well, I mean, so that the board clearly has, you know, what you want it to have before it. I would suggest.
Okay.
Okay.
And I certainly will. I do not, however, consent to any further additional statute of limitation, but certainly we'll put that in writing. New York State Town Law 267, titled Zoning Board Appeals, specifically paragraph 6, but I'll include the entire law.
Okay. You're entitled to submit whatever you want to submit. I would say to the board from a legal position, I disagree, but that the board will get to when it ultimately makes its decision. Mr. Rotolo, let me ask you, based on your most recent submission, this now has come before the board twice, anticipating a public hearing. On two occasions, the applicant's requirements with respect to notice to neighboring properties and signage have not been met for the reasons that you have expressed. If I could, may I ask you do you intend to do what is required on behalf of the applicant with respect to the giving of notice to neighboring owners and the posting of notice of the public hearing?
No, sir, for all of the reasons as stated in my submission,
Mhm.
which is the way the New York State Secretary of State identifies as a special use permit, and for all of the deficiencies with the legal notice and so on. So for all of those reasons, I do not, sir, intend to comply with that. And it's not a matter really of being picayune or anything like that. I mean, there are questions, substantial questions as to whether, I would be violating Penal Code section that pertains to submitting a false instrument for filing and other things. The New York State Secretary of State specifically says this is purely an administrative function requiring that standards be set out in the zoning guide to guide the Board of Appeals in passing upon applications. I merely submitted a request for a special use permit based on, and if you go to page 21 of the material that I sent you, and I understand that this material was sent to everybody, what I asked for, page 21 of the handwritten, numbered page, is a special use permit to operate in a matter that was already agreed with the prior building inspector and already approved by the Ulster County Board of Health and approved at a good amount of money to me by hiring an engineer, putting in low flow toilets, dual flush toilets, low flow shower heads, paying for engineering costs, assessments, filings, and all that stuff. And it was already agreed that we would do this with Mark Jaffe, and I thought we had that agreement in place. So what I'm applying for now is very de minimis. It's not a zoning variance. It's not a use variance. I am merely applying for a special use permit to be able to operate as previously agreed. Really, that is all that I'm applying for, nothing else.
From a legal perspective, I understand the argument. The board and the applicant is also aware of my prior letter regarding the ability, the jurisdiction of the Zoning Board of Appeals to grant the relief requested. I've advised the board that it does not appear from my research and the local law on the allowed uses within the zone that it is within the jurisdiction of the Zoning Board of Appeals to grant the relief requested at all. And that relief requested for a multifamily purpose, in my view, also cannot be granted by the planning board. Because actually, Mr. Rotolo is correct. It is an administrative decision to be done by the Zoning Board of Appeals. And unless there is authority in the local zoning law that allows the Zoning Board of Appeals to grant the relief, the Zoning Board of Appeals can't grant the relief. And it is not an allowed use within the zone by special use permit and may not be granted either by the Zoning Board of Appeals or the Planning Board. I invited the applicant to address those legal concerns at a public hearing if he chose to. There's apparently not going to be a public hearing, but I understand Mr. Rotolo on behalf of the applicant disagrees. But I'm firm in my legal position that it is relief that's not allowed. Stacy, I know, had her hand up.
Stacy?
I just want to make you and the board aware that I explained to Mr. Rotolo that this was not the proper application for this particular project. I explained to Mr. Rotolo that this should be a use variance, to which he informed me that I was not qualified to make that determination, that the Zoning Board of Appeals would make that determination. Mr. Rotolo did file variances.
We're kind of losing you.
Yeah. Can I respond to, I honestly don't remember ever using the words "you're not qualified," honestly.
I'm not finished.
But,
Which he
okay.
had made applications for use variances, which he withdrew for his reasons. And this application filed to the ZBA as use variances, special use variances. The ZBA, this is not. The ZBA cannot issue this because there is no application within the code for the ZBA to issue this kind of permit for him. So, yes, Joe is absolutely correct.
Okay. I would like to read into the record that Stacy Deladere sent me an email saying there are a few pre-existing non-conforming constructed or converted with COs or constructed prior to 76 multiple dwellings in the located R1 zones. Now, first, what I'm applying for is not even a multifamily. I am applying to use it as a single family. If you look at page
Mr.
21.
Mr. Rotolo,
Yes.
Yeah.
Yes.
we are here tonight to make a decision if we are going to have a public hearing or not. You have not complied with the requirement of notifying your neighbors and placing the sign in front of your property to let anyone passing by know that there will be a public hearing with regard to this particular issue. You have not done that. So at this point,
No, I have not, sir.
you have not done that. So at this point in time, based on our attorney's advice and what I have heard, there is no need to continue any further with this discussion. Joe,
Yeah, Len, if I may.
please.
There's a great deal of objection, especially in Mr. Rotolo's most recent submission about the public hearing. I would recommend to the board at this time that the matter of the public hearing simply be continued till its next meeting. I don't want to advise the board at this point to take the public hearing off the record at this time. The matter was originally scheduled for a public hearing to be held. It hasn't been held. I think it can be continued to the next meeting for this purpose. I've done a lot of research into this for members of the board. And in light of all of these submissions, I would like to recommend to the board that I be given an opportunity perhaps to submit something to the board along the lines of a proposed decision that marshals the evidence with respect to the setting of the public hearing and the arguments that have been made that it's been untimely, with respect to the issue of the applicant's failure and refusal to comply with the notice provisions for public hearing with respect to the issue, especially in light of his admission tonight that he doesn't intend to do them. And I realize he doesn't intend to do them. That's his right if he chooses to do it. But a proposed decision should address that. And a proposed decision should address the board's ability or lack of ability to grant the relief requested. I would recommend, unlike many times the board is used to making a resolution, holding a vote, moving the matter along, which I understand and appreciate. I think in this particular case, to protect the record, to protect the board from any subsequent litigation by the applicant, I'd like to see this board entertain a written decision that's going to contain all of this information, and if the board agrees with it, it will be decided and it will be filed with the town clerk, after which the applicant has a right to avail himself of Supreme Court in an Article 78 proceeding. The board, of course, was not obligated to take what I submit to it as its decision. That's why I would send it to the board members in advance. They should look at it, review it, and as always, they should discuss anything at their next meeting in March.
Your advice is
Uh,
well
I would
taken. Now, at this
would
particular point in time,
Wait a minute.
I would ask that for a continuance of the public hearing from Mr. Rotolo to the
I
March
would-
meeting of March 10th. I entertain a motion to contain that.
Have
And
we,
that's
in fact,
forward-
opened the public hearing?
Excuse me, Amy?
Is there a public hearing on board?
This
right
evening,
now?
this evening, there is no public hearing because,
Continuation.
yes, this is a continuation.
Oh, okay.
Joe, you were
Okay.
going to say something?
Well, I think there was going to be a comment by the agent for the applicant, Mr. Rotolo, wanted to say something.
Thank you, sir. Yes, I would request that the administrative function as identified by the New York State Secretary of State, which is what it says is a special use permit, that I be granted that. And furthermore, that what I'm asking for is a special use permit specifically consistent with page 21 of the attachments that was attached to my application originally. Can I get on the record who was appointed? I know that at the December 9th meeting, I was told that there were 2 new members. Amy, I think, was one of them. Who was the second member?
My suggestion is that I would recommend you speak with the town clerk to get that information correct.
Okay. Also, this will be my last comment. According to the New York State Secretary of State, it says that the Board of Appeals is an administrative body of limited jurisdiction and powers designed to function as a safety valve to relieve the pressure of rigid and inflexible provision of the zoning regulation. Again, this is the second paragraph of page 9, hand number page 9 of what I sent you. It is a very minor thing that I'm requesting, that based on what the New York State Secretary of State says, it's an administrative function, and the Zoning Board of Appeal is designed to function as a safety valve to relieve rigid and inflexible provisions of zoning regulations. When you take this information into account, I don't think that we need a public hearing, but also most important is that when the public hearing was voted on, 2 members who were not allowed to cast a vote, there was no quorum because Steve Esposito recused himself, and the 2 board members were precluded from voting as per section 267 Zoning Board of Appeals law, which says that no such additional member shall take part in the consideration of any matter for which an application was on file with the Board of Appeals at the time of his or her appointment. So based on that information, I kindly request that the administrative function of issuing me a special use permit as previously approved by the building inspector and agreed to with the building inspector, that this was all done, to issue me a special use permit as is detailed in page 21 of my submission for today. And I thank you all, and I'm sorry if I took up too much time.
Stacy?
Yeah, I would just like to say that, no, nothing was agreed with the building inspector. Mr. Rotolo was advised that it should not be a special use permit that he should be seeking, that he should be seeking use variances, and that's all I have to say on this matter.
Yeah, I absolutely dispute that. I have no recollection of that whatsoever.
Okay.
Just Glenn, for the board, I'll just say that I disagree with Mr. Rotolo's position with respect to the vote of the members at the time that the public hearing was set. It was a vote to set a public hearing on a filed application. And I do not believe as a matter of law that all of the members present who had not recused themselves, I don't believe as a matter of law that they could not do that. The only action that was taken in that vote was to set a public hearing. So
Right.
I disagree.
The board voted
Or not to be swayed
set
by
a
that
public
argument.
hearing. Okay, I'll entertain a motion for a continuance of this public hearing for Mr. Rotolo for 139 State Route 208. Is there a second, please?
A second.
Thank you, John. All those in favor signify by aye.
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 Aye, okay. At our next
And
hearing, at our next
Okay,
meeting, Mr. Rotolo, we're on to the next item. Thank you very much. You're welcome to
Okay.
listen.
Len, if I
Okay.
could,
Yes, John.
would you ask the board, if the board members would want to authorize me to make a submission in response to Mr. Rotolo's submissions in time for its meeting in March?
Yes, I would.
On these limited issues.
Okay, I'll entertain a motion for Attorney Moriello to make that recommendation for our March meeting. Is there a second for that?
I second.
I second.
Seconded by Amy. All those in favor signify by aye. Aye.
Aye.
Aye. Okay, motion carried. Thank you, Joe.
Thanks, Len.
The next item is a public hearing for 6 Oak Street. The applicant's Mike Stepanovich. Amy, have you received his letter of notification?
Yes, he submitted everything.
Okay. So at this point in time, entertain a motion to open a public hearing for Mike Stepanovich for 6 Oak Street. All those, I need a second, please.
Second.
Seconded by Catherine. All those in favor by aye?
Aye.
Aye.
Okay, thank you. The public hearing is open. The first thing, Mike, Mr. Stepanovich, if you could please give a brief synopsis as to what you're doing, as there may be other people signed on that are not familiar. I do realize that you spoke with us at the last meeting, but just give a brief overview, if you would please, as to what you're hoping to accomplish.
Yeah, no problem. Try to keep it short and then take any questions. So we live at 6 Oak Street. It's the end of a cul-de-sac. We don't really have anyone to the left, right, or behind us. Our house is about 1,500 square feet, so it's, modest size home. And we're hoping to put a sunroom off the back of the house, which wouldn't be visible from the front of the street. The kind of code requires you to have 50 feet clearance from whatever you have on the back of your house to the next property. Behind us, the next property is just woods. It's a vacant lot that's there. So the whole area is a very wooded area. So we are requesting a 6-foot, 10-inch variance. We think we only really need 5 foot, 10, but we're going to do an extra foot just for padding, as we discussed in the last kind of public hearing. So really, it's an area variance for the offset to the back of the property for a sunroom to be added to the house.
Thank you.
Sure.
Anyone have any comments? Amy?
Mr. Stepanovich, there's a currently existing shed and you plan to move it slightly so that it comes closer to meeting the requirements?
There's a
Amy, I think that's the other application.
Oh,
To
I
the shed. Yeah, this is the public hearing for 6 Oak Street.
The sunroom.
Yeah, it'll be a building of a new sunroom. So there's no moving any existing things in this one. It's really that we were requesting, instead of having 50 foot off the back, it'd be like 43 feet 2 inches off the back.
Anyone else have any comments with regard to Mr. Stepanovich's application on 6 Oak? Yes, John?
One quick question. I just was curious in looking at the plans that you drew up. you have a lot of room behind the house there. I just wondered if you had looked at any alternative design that wouldn't require a variance. Like, for example, you might be able to keep the same total area by having a narrower and longer room. Did you try to do anything like that?
Definitely. No, we did try. I mean, if you look at the house, we can't go to the right at all because we have our septic line goes out. So really, we have to kind of leave room there. So we can't go out to the right. And going out to the left, we start to kind of hit like the chimney and other things. And then really one of the issues with it being kind of more narrow is that there is a staircase that will be going down into the basement from the room. So you almost need the room to be a little bit wider in that direction towards the back of the property, because when you have the 3 foot for the stairwell to go into the basement, which is already an existing stairwell that's there, and then you have the doors on the room on the other side, if you don't have this variance, you end up with like 7 foot of room in the middle of the room, and it just gets to be so narrow that it's almost not as usable as a space. So we did try to understand like where it could go, and there really aren't a ton of options.
I got one other quick question. I think
Sure.
you described the neighboring properties as being woods. Are there residences on them?
No, the lot that this would butt up against is an empty lot that's owned by the house next to it, meaning like on the other side of that lot. So that gentleman owns 2 lots. The one next to us it's purely woods. There's nothing there. And then the next lot over is the person that owns that lot as well. And their home is closer to Libertyville. I don't know if anyone knows the area, but most of those homes are closer to the road on Libertyville. We are at least, it's about almost more 2 acres up at where our property is. So even where those houses sit, it's quite a distance. You really can't see any homes out of the back of the property.
Okay, thanks.
Sure.
All right, thank you. Anyone else have any questions? Anyone from the public have any questions? Okay. So at this time, I would entertain a motion to close the public hearing for 6 Oak Street.
I do.
Joe, you have a question?
I have to unmute. Sorry. Before you close it, for the record, are there any other submissions by any members of the public or neighboring property owners with respect to this application?
No.
Okay.
Okay. None, Alana?
No, I didn't receive anything.
Okay, I didn't receive anything either. Okay, at this point, I'll entertain a motion to close the public hearing.
So move.
Thank you, Amy. All those in favor signify by aye.
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 And I myself. Okay, Stephen, are you back with us?
Yes.
Okay, thank you. I just didn't see your picture.
It's
Okay,
there.
so we've closed the public hearing. Open for any discussion. Any of the members of the board have any discussion with regard to this application? I guess not. Okay. The next thing we need to do, there are 5 questions that need to be answered before the decision is to be made on the granting or the denial of a variance, and here they are. And if the applicant could just answer yes or no, please. Whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will created by the granting of this area variance.
No.
Whether the benefits sought by the applicant can be achieved by some other method feasible for the applicant to pursue other than the area variance.
No.
Whether the requested area variance is substantial.
No. It's about 13%, 14%.
Okay. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district.
No. It's off the back of the house, yeah.
Okay. Whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the Zoning Board of Appeals, but shall not necessarily preclude the granting of an area variance.
Yes, I mean, I don't have to build a sunroom off the back of my house, so I did create this by choosing to do that.
Okay, I understand your answer. Okay, any more discussion on the board? From the board? Stacy, anything? Joe?
Yeah, I would just, well, if there is a resolution to approve the variance, I think that the resolution should include that the variance is being granted, if at all, in conformity with the plans that have been submitted to the Zoning Board of Appeals that it has reviewed. So the size of the room and its dimensions doesn't change simply because there is a setback variance. The room isn't going to get wider for the applicant, is what I'm trying to say. I mean, the variance is going to be limited to the plans that have been submitted, but to the board, because that's what the board is looking at. Stacy has her hand.
Hey, Stacy?
The room wouldn't get wider because the width of the room is what's creating the variance. You don't want the room to get longer.
I'm so, well, right. Longer on both sides of the drawings in the application. So the
Well,
applicant understand where I'm going with this?
Yes.
And the architect? Okay, I mean, it's basically, if granted, limited to the drawings that the board reviewed in the granting of the variance.
Understood.
Okay.
Entertain a motion for approval as per plans submitted with a giving of a 6'10" variance.
I
And
approve it.
John?
I'll second Steve.
Okay, thank you, John. Well, the rest of the board, please take a vote.
Yes.
Yes.
I
Yes.
approve.
Stephen, are you there?
Yes.
Okay, unanimous vote. Variance has been granted.
Thanks, everyone.
Okay, have a good night.
Take care. Appreciate it. Bye.
Okay, let me just finish filling out the paperwork. Alana, I will drop this off tomorrow at the town hall.
Yes, I'm good. I'll be there tomorrow.
Okay, all right. Okay, next item on the agenda. Okay. Application review. 290 Old Kingston Road, Keith Leibold. Mr. Leibold, are you there?
Yes, I'm here.
Good evening.
Good evening.
Could you please explain to us and any other members of the public that may be signed on to this Zoom meeting as to why you're here, hope to accomplish?
Yeah, absolutely. So I made a mistake and put a shed on my property prior to pulling a permit. That came up when I and my neighbor resolved some boundary or an internal lot line. We adjusted it to clean up a shared boundary, and this came up. And even with the lot line adjustment, I will not be compliant to the 50-foot setbacks. I can be compliant by moving the shed on one of two boundaries. And so I'm seeking a variance on that.
And this is Patty Brooks speaking. I also am here this evening representing the application. I made application on behalf of Mr. Leibold. Again, as he stated, because of topographic conditions, we're not able to meet the 50-foot rear yard setback. But because of the lot line revision, we are going to be able to move the shed to the north such that the southerly boundary line or the side lot line of 20 feet will be able to be met. We did submit maps showing the topography at the site and the practical difficulty in relocating the shed elsewhere on the property. Obviously, the applicant's first choice was to leave the shed exactly where it is, which is only 10.5 feet off of the southerly boundary. But we are cognizant of the fact that the board needs to grant the least variance possible, which is why the applicant is willing to go through the effort to relocate the shed to the north, although it will not be possible to meet that rear yard.
Just for the record, so the public would know, this is on the location of this property being discussed is 290 Old Kingston Road in the town of New Paltz. There was, it's my understanding, there was a lot line revision going on. Has that been completed?
The lot line revision has received final approval, and we are looking to file the map with the county clerk. We have an appointment to do that on Thursday of this week.
Stacy?
I just have one technical question for Joe Moriello. We received the resolution of approval for this lot line revision, and one of the general conditions of that resolution of approval, it says that this resolution of approval is further conditioned upon all other approvals or permits that are needed by operation of federal, state, and local regulations, including but not limited to the Army Corps of Engineers, New York State DEC. There's a special, hang on 1 second. I think there's a special condition. Yes, specific conditions by resolution of the approval. The planning board is not approving the use of or the property of the location of the shed located on the existing parcel identified as section 78.15 block 1 lot 2. Such shed must comply with all town of New Paltz code requirements, including permitting and setback distances. I just don't know where this resolution for approval on the lot line revision holds with this application to the ZBA. So I guess I'm asking for clarification from council for the ZBA on where this puts this application.
So if I could just, before Joe comments on that, I just want to complete that entire thought process. We had gone back and forth with the planning board with regard to that because the attorney for the planning board recommended that the planning board could approve the lot line revision, but state that that lot line revision had nothing to do with the shed because it was outside the jurisdiction of the planning board authority. So the note that was placed on the map that was granted approval said, by resolution of approval dated January 11th, 2021, the planning board did not approve the use of or the propriety of the location of the shed located on lot 1. The placement of the shed must comply with all town of New Paltz code requirements, including permitting and setback distances, unless any applicable and appropriate variances or approvals are obtained. And then we were directed by the planning board to seek relief from the zoning board of appeals, which is why we're here this evening.
Yeah, and just to clarify, Joe, the map that was signed by the planning board does state that. So, but I just wanted clarification because of the way the resolution was written.
Absolutely.
Yep, Joe, we can't hear you.
Sorry.
Okay, again, please, from the beginning.
I noticed that stipulation, that condition in the approval of by the planning board, Patty. So that note will appear on the subdivision map that is about to be filed in response to that resolution. Does that answer your concerns, Stacy? With respect to this application, you're on mute, Stacy.
I mean, it does. It just appears that there's a conflict between the resolution and the actual map.
Patty, do you think there's a conflict between the resolution and the map?
I can provide Stacy with the email string between myself and the planning board attorney, because I said that I had a concern that if the resolution was left the way it was, that I was afraid just this would happen, that there would be a lack of understanding that we were being authorized by the planning board to seek that relief from the zoning board because the planning board couldn't provide it. And I can tell you that the map that was signed by the planning board is the note that I just read. And it was through agreement by the planning board and their attorney.
So, yeah, so that email string would be fine for my records.
Okay.
Okay,
Thank you, Patty. That helps.
good.
When the board has to set a public hearing on this anyway, right, Len?
Yes, that's next.
And it has to be referred to our town planning board to get its recommendations, I believe. Right, we submit this application, Stacy, has to go to our planning board to get its recommendations.
Its recommendations prior to us making a decision.
Prior to a decision, yeah. So at the time, generally, that you set the public hearing and send the notices, we're going to send notice to the town planning board.
Correct.
That this has been set down for a public hearing, and then they have an opportunity to submit
Comment.
whatever they want to submit.
Okay.
I don't think it has to go to the county.
Stacy, where is its proximity? I mean, that runs parallel to 32.
Patty, is it within
I've got my trusty scale. Give me a minute here.
feet of?
Okay.
According to the tax map, the back of the property is scaling about 450 feet from 32.
Oh, yeah, it's gotta go to county.
Yep.
Okay. Well, did it go to county for the subdivision?
No, subdivisions don't require GML review.
Okay, all right. Okay, so, Alana will be sending that to the county.
Oh, you're going to set a public hearing?
I want to hear what Stacy has to say first. Stacy?
I'm also looking for clarification because the building permit application we have is for 25-foot setback.
From Mike Tierney, new phone.
Patty has submitted an application for a 20-foot setback. So there's a conflict there. And I'd like some explanation on why it's 20 feet, not 25 feet. So Keith, Patty.
Well, that was one of my questions. Is it 20 or 25 feet? The plan is drawn for 20?
The building permit application that I received is for 25 feet.
Okay.
Various applications for 20 feet.
I did not fill out the application, but I recommended to Keith that based on the topography and where the shed is right now, I recommended a 20-foot rear yard setback. I believe Keith might have actually put the application in for the permit prior to me doing an analysis on the topography, but Keith, maybe you could clarify that.
Yeah, no, I did. When this was all first discovered, I went in to pull a permit to rectify the wrong. I honestly had no idea the setback requirement was so great. So I thought this was a simple pull a permit, pay a fine, and have egg on your face. So that permit is not, I would get rid of it at this time because it sounds like it's just confusing things. And it's going to be resolved first with a setback, and then I'm sure I'll have to pull the appropriate permit.
20 or 25, Stacy?
Yeah, whichever is appropriate.
Which is appropriate, the 20 or the 20?
Well, I mean, the more conforming, the better. Mr. Leibold's a contractor, I believe. Ms.
I
Brooks
do
is
my best.
there. So, it's, the more conforming, the better. However, they're the applicants. They're the ones making the application. I have an application for 25 feet. The ZBA has an application for 20 feet. We need clarification of where it's going to go.
All right.
Can I withdraw the permit and just formally withdraw it, and then I can submit a permit?
The permit is really what gets you here. So you can amend the permit, but
Sure.
let us know what you want to do.
Yeah, based on the proximity of the existing shed to the boundary line and my inspection of the site and the topography, already the shed at the closest point is about 16 feet from the boundary line. So we're already moving it up the hill 20 feet. And Keith, without you doing regrading in that area, I'm afraid it's my opinion that the 20 feet is really what
Is going to push it. Yeah, I'm afraid to do any kind of digging there. That's the septic field. So I can push right up to it, but then once I hit that hill, Patty, I can't dig into it.
So I would suggest that you revise the application to 20 feet.
Okay.
The permit application,
The permit application,
Okay.
building permit application.
because the
So the
application
plan-
before the ZBA is for 20-foot variance.
Correct.
That's going to stay as is.
That is what I recommended based on my site inspection, the topography, and where I know the boundary line is.
Okay, so you will amend that. Mr. Wendell?
Yes, I'm sorry. Broken.
Okay. Okay, I entertain a motion. Do any of the board members have any comments before we entertain the motion to set the public hearing? No. Okay, for this point in time, I'd like to entertain a motion to set the public hearing for the required 20-foot setback for shed located at 290 Old Kingston Road.
So I so move. but
Thank you, Amy.
Could it say a 20-foot rear yard setback? Because
Okay, we can add that because that's what it is. It's a rear yard setback.
It's actually a 30-foot rear yard setback because we have 20 and we need 50.
but I just want the motion to reference that what you're asking for is on the rear yard, not the side yard.
Okay.
Okay. Entertain that motion as so amended.
Aye, yes.
Okay. Seconded by John. All those in favor signify by aye.
Aye.
Aye. Okay, so the public hearing for the variance for 290 Old Kingston Road will be at the March 10th meeting.
Thank you. We will be sure to do the appropriate notifications and posting.
Okay, thank you very much. Alana will get you those. Sending it to the county, Alana,
Yeah.
got it?
Yeah, I can do that.
Okay, thank you. Okay, next item on the agenda.
Let me know.
Yeah, sure.
Next item on the agenda is Trans Hudson Management Corporation.
Good evening, Mr. Chairman and members of the board.
Good evening, Ms. Atlantis. For the people that may not actually be familiar as to why or for what reason you're here, there are basically two items on the table. One has to do with a drive-through and the other one has to do with a second story. So if you could elaborate on that, please, just to fill the public in or anyone else and the board members, it would be appreciated.
Sure, we're actually seeking 3 variances from this board. One is from the building height requirement, requiring a minimum of 2 occupiable stories. And that's under 140.22.2 C7A. And then we're also seeking a variance to design standards. Again, the same design, the same issue about the 2 occupiable stories and a drive-through window for food and beverage service uses. And that is under zoning code 140.22.23A and C. Just to give, I don't know if you want some background on the history of this property or to get into the request itself, but this is probably the first and only variance in all of New York State where the applicant is asking to do a less dense development and not as high as development as allowed by code. You probably don't get a lot of these type variances, I'm sure. I've heard a lot about the intent of this newly created zone, but whether a zone was created 5 minutes ago or 20 years ago, the standard applied by this board is the same to granting an area variance. And I also heard and read some of the comments that were submitted to this board, and a lot of the comments were legally irrelevant for this board's consideration in granting area variances. You should have our letter before you dated 2/26/2021. That is our position, and I could just briefly give you some background on this matter. My client's site, I don't know if you hear that now, but my client's site plan application has been pending since 2013. The planning board issued a secret neg deck back on May 3rd, 2017. During what we thought were the final stages of site plan review, the town board adopted the Gateway Area Rezoning Law. We commenced a litigation challenging that, both under SECRA and as unconstitutional and unlawful as applied to the property. But in the effort to avoid a prolonged litigation, my clients really worked long and hard to come up with this concept plan that incorporated many of the features of the new zone and also tried to incorporate some other features and presented it to the planning board and really got some positive feedback from the board. And really there's 4 ways that the plan was different from the plan that received the neg deck. One is that the village had indicated that they would allow this project to connect to municipal water and sewer. And obviously that's something we would still have to go through the process, and that would be decided in the context of site plan review, but at least we received the indication. More importantly, this project offers greater amenities to the town. This project provides an extension of the Empire State Trail through the entire property. My clients are proposing to not just develop typical commercial/retail spaces, but also develop municipal spaces. They're proposing 19 municipal parking spaces along with a municipal restroom. You're going to have a mixed use layout, and this is probably one of the first few retail commercial uses with this municipal recreation use. And the new layout is much more consistent with the Gateway Area Rezoning. It really meets the vast majority of the requirements. It's a village type feel with the buildings facing the street and the parking in the back. And like I said, it complies with the vast majority of the requirements. But what it doesn't comply with is 2 occupiable stories, and we'd like to put a drive-through on a food establishment restaurant. As we went over in our submission, and we could get into more detail, there's no undesirable change in the character of the neighborhood. We showed you that the vast majority of surrounding retail/commercial uses are 1-story free, that are freestanding buildings are 1 story. Actually introducing a 2-story retail or commercial building would be inconsistent with the character of the neighborhood. And with respect to drive-throughs for food establishments, there's a Burger King and a McDonald's in the right nearby that have a drive-through. There is no other feasible method. It's not financially viable to construct a 2nd story on a freestanding retail space of this size. We submitted a letter from an expert in that regard. Also, in this climate, no food establishment will.
Message is received from Sticky New Paltz and Pecker.
Would lease space without a drive-through. And again, we submitted a letter from an expert in this regard. My client has been in this industry for years and is prepared to speak to this point. The variances can hardly be characterized as substantial. Again, we're seeking to do less development, less density, and less height. But even if you characterize them as substantial, courts have found that even when there's a self-created hardship and the variance is substantial, it was an error to deny the variance when there was no change to the character of the neighborhood. And here, again, I point to the evidence that we've submitted that shows that clearly the character of the neighborhood is one-story, freestanding retail and commercial buildings. And there's no impacts on the physical or environmental conditions. This is the opposite of an adverse impact on physical and environmental conditions. First of all, again, we already have a neg deck issued for a project that was more intensive, larger than this project. As for the drive-through, the current zone doesn't prohibit drive-throughs. It just prohibits drive-throughs on food establishments. So really, from an environmental perspective, what is the difference between a drive-through on a bank or any other kind of drive-through on a pharmacy versus one on a food establishment? And unlike most variance requests that come before this board, there's a benefit to the community here. We are not just proposing a private development. We're proposing a development that has a municipal concept to it. We're proposing a municipal trail, municipal parking spaces, and a municipal bathroom. And those are recreation areas that the entire town and community can benefit from. I just want to quickly address, just so we could focus on it, some of the comments that I've received so far about the intent of the gateway zoning, and many people view it as sacrosanct, this gateway zoning. But really, from this board's perspective, it's no different from any other zone in the entire town. This board can grant a variance from the requirements like it can from any other zone in this town. The question about the fact that we don't have the will serve letter from the town indicating that the village, we've only had informal assurances that there will be municipal service provided to the site. We understand that, of course, that's something that we are prepared to pursue during the site plan process, and that's the appropriate time to pursue it, but that's not really a criteria for granting or denying an area variance. Somebody also brought up maintenance of the restroom. Again, another issue that will be resolved in the context of site plan review, but not a basis for granting or denying an area variance. And another comment was that the drive-through is really a use variance, and that's just wrong, completely wrong as a matter of law. Whether you have a food establishment with a drive-through or without a drive-through, the use is the same. It's still a food establishment. And there's a case that's exactly on point where Mobile Oil against Village of Mamaroneck, and in that zone code, they prohibited canopies on gas stations near residential zones. And the zoning board determined that the request to have a canopy on a gas station in a residential zone was a use variance. And the appellate court said, no, it's an area variance. Because in that case, the petitioner was not seeking to change the essential use of the property. And this is what the court ruled, and I quote, "The canopy is only a physical and dimensional characteristic in this respect. The essential use of the property will remain as a gas station even with the erection of the canopy." And this is the same thing here. The drive-through is a physical characteristic, and the essential use is basically the food establishment use will remain the same, a food establishment use, whether there's a drive-through or not. So what you have before you is an area variance request, not a use variance request. And I'm happy to answer any questions that the board members may have regarding this application.
Joe?
You're muted, Joe.
Go ahead, Joe.
Yep. For Ms. Salantis, do you have a citation on that case?
Yes, Mobile Oil Corp v. Village of Mamaroneck Board of Appeals, 29382nd 679, and it's out of the second department. And I'm sure I could also find some third department cases in that regard, but we just recently got the comments, but we could certainly look into that.
No, I understood. Thank you.
Thank you.
Yeah, I have a question. Maybe
Yes.
this would go to Joe as well as anybody else. And it's procedural, so bear with me because I don't really quite understand exactly how this has come before us. Has the applicant had a site plan application denied and told that they need to seek a variance? Is that accurate?
So what happened is that we had a site plan application that was nearing its final stages. At that point, there was a rezoning, which essentially forced us to reconfigure the site plan to comply. We've presented a concept plan to the planning board. That's what I was mentioning. We got the positive feedback from. Under this rezoning, you have two alternatives. You can either seek waivers, or like any other code provision, you could seek a variance. We attempted to seek a waiver from the planning board, and I apologize for failing to mention this. The planning board granted us the waiver.
Well, excuse me for cutting you off. I know that story. I guess my question is more technical. This concept plan that you have presented is not the same thing as a site plan. Am I right?
Correct. There's been a determination by the building inspector that to move forward with this plan, we would need a variance from the bulk provision. And the other two are design criteria, which we could either seek variance from or a waiver. We've pursued the waiver route.
Okay, so I have no problem understanding the request for a waiver about the bulk area regulation. That I understand. I don't understand how addressing these two other design standard things would come under the category of an area variance.
So the bulk waiver is the same exact thing, and it's just been put in two places of the code. So the one.
Well, no, it's not. It's one of them is a bulk area requirement, and the other is a design standard. It's two different things, as I understand it.
Well, it's two different things as it's written in the code, but they're both code regulations, and any zoning code regulation is subject to a variance. So it doesn't matter what somebody called it, either thing is subject to a variance by this board. It's no different from any other regulation. You could call it many types of.
This is something I would like to talk to our attorney about, maybe in an executive session at some point or some other time. I'm very much not clear on this.
I understand. Really the law is clear. If it's in a zoning code regulation that restricts the use of property, it has to be strictly construed, and it's subject to the granting of a variance by this board. This is a zoning code regulation, no matter if it's called a design standard. It doesn't specify that it's a bulk standard either. That's just what it is. It doesn't say these are the bulk standards and these are the design standards.
I know the definition of the area variance, and this clearly doesn't fit that, and that's why I'm confused about why it's being sought as an area variance.
I'm not clear why it wouldn't fit the definition of an area variance when seeking not to apply a height requirement in the zoning code. That's
dimensional or physical
area
requirements. Dimensional or physical requirements. That's what
it's a physical requirement. It's a dimensional requirement in this code that it's requiring design standards. Why isn't that a dimensional requirement?
Well, again, I'll let it go for now. It's something I want to clarify.
I understand.
Oh, do you have any comments on that? It seems to me that a height thing is an area variance.
I'm having a hard time hearing you, Amy.
I just wondered whether you had an opinion about whether a change to a height restriction is an area variance or not.
Well, I think that the request is with respect to the height and bulk relations or the height and bulk regulations within the code that apply within the district. And I think the argument that the applicant makes is this would be for an area variance. I don't know if any of the members on the board at the moment were involved in the variance application with respect to the hotel on South Putt Corners Road.
No.
Hampton Inn. I don't think anybody was. There was that was a height. There was a height limitation there, and the applicant sought a variance from the height limitation with respect to the hotel and the placement of, I think it was air conditioning equipment. So it was an area variance. Stacy, you were around. It was area. It was not use. I don't think that any of the issues are being addressed tonight would take away from the board's authority to set this down for a public hearing. However, I think you can set it down for a public hearing. The applicant is obviously aware of what some of, at least, of the arguments are and will be at the time of the public hearing. She's addressed some of those tonight. I suspect you'll address them further. This may be another issue for you to address, Kathy, as you come for the public hearing. The issue as to whether or not there is some distinction between the design standards and the height limitations. I'm not prepared tonight to say that there is a difference or that the board is prohibited from issuing a variance if that's its final determination. Right?
I will certainly address that further, but it's a restriction in the code, and both restrictions are area variance. But
Otherwise, no applicant would have any ability to seek relief from the Zoning Board of Appeals if the zoning law decided that everything was a design standard.
Right.
There'd be no way to use that safety valve that we've heard about earlier tonight.
Well, the basic purpose of this evening's meeting is an introduction. And I'm hoping that any questions that the board or the public may have will be open for clarification during the March 10th meeting when there will be a discussion. John?
Yeah, just to make clear, my concern is really just to make sure that we're following procedures that won't come under question at any point, that we're doing things that we're authorized to do according to the way it's supposed to be done.
Right.
That's where I'm coming from.
And I think that the board is. I think when the board gets this application, essentially its obligation is to set it down for a public hearing.
Right.
You've got to go forward with the public hearing. Things may emerge at and after the public hearing that makes a difference, but you really, at this point, all you really can do and should do is set it down for a public hearing.
I understand.
Yeah.
Catherine, Ms. Salantis, do you have anything else to add, or the owner of the property have anything that they'd like to add?
Yeah, my client is here and would, I believe he would just like to say a few things.
All right, open the door.
Bear with me.
Good evening.
Hi. Mr. Chairman, members of the board, Kathy, I'm not sure this is an appropriate time or place for me to speak.
We could certainly wait to the public
public hearing.
Yeah, this is basically an introduction as to why you're in front of us, and we will dot the i's and cross the t's, hopefully at the public hearing.
Okay, so we'll wait for the public hearing.
Okay,
Thank you.
thank you very much. Okay, I will entertain a motion, or I'd like to entertain a motion, if we could please, for the applicant Trans Hudson for its request for variances in regard to the 2 occupied story height issues, the height issue for the 2nd story, and the drive-through.
Sounded like only 2. Could you repeat that, Lynn?
Okay, the first one was the height issue of the 2nd stories, 2 occupied stories. And the second one is for the first is for the you have one for the design standards and one for the bulk table uses. Catherine, am I correct?
Right. So essentially, the 2 occupiable stories appears.
Yeah. They appear that they are affected by 2 things, and the last one has to do with the drive-through. Okay. And I'll entertain a second for that, to open that, have that public hearing at our March 10th meeting.
Second.
Thank you, Amy. All those in favor signify by aye.
Aye.
Aye. Aye it is. Okay. Thank you.
Thank you.
Okay. So at this point in time, I have nothing else to discuss at this meeting. Anyone have anything else that they would like to speak about?
I just have a question for the Trans Hudson application. Does
Yes.
that have to go to county? Does anyone know off the top? I mean, I can check
Yeah,
tomorrow.
I think it does. It's North
It's
Butters
close,
County
right?
Highway.
Yeah.
Yeah.
Yes, it's proximity. That would go to county.
Okay. Thank you.
Thank you, Alana. Good suggestion. Stacy, I see your head. Do you have anything to say, or are you just moving?
No, yes, it definitely has to go to county. Is it ready to go to county, Joe?
Yes.
Well, we can submit it. I think they really are looking for a full submission, so the submission may end up not being complete until you've got more input after at the time of the public hearing. But
well, I think
Stacy, I'd let you know, is there any problem with us sending it up and giving them notice early that there's an application?
Well, the only problem with county is that if you send them an incomplete application, they may kick it back and say, your application is not complete. We haven't gone to public hearing, so on and so forth. So
I've sent stuff to the county before there was a public hearing. The question is just like if you're anticipating that they're going to be submitting more materials that you need to make your decision, the county should see everything that you guys are seeing. So
that may happen.
Yeah. So if you think that, and they only meet once a month, they meet the first Wednesday of the month. So you could set the public hearing for March, but then there's a chance that the county won't see the materials until April. So that's just a possibility that might happen. I mean, you might end up keeping the public hearing open anyway until April, depending on how many people come out for it. So I don't even know if that would matter.
Usually when we have applications that go to county, it's usually a 3-meeting application.
Yeah.
This is one of 3.
It seems to me, we know that they will want more as part of the submission.
Mm-hmm.
But it seems to me that maybe under these circumstances, we should send it up. We may end up having to supplement it to the county with additional information that comes forward at the public hearing. And I would hope that the county planning board would understand that.
I mean, I could send it to them and mention that more, would they even want me to say, well, more will be coming, or will they just tell me, no, wait until you have everything to send it?
Would it make sense to call them?
I can. I can call Robert and ask.
Give them a call and let's see what they say. You don't have to send it within the next 5 days.
No.
So let's see what they say, and if at some point they want to have us wait for the submission, we can do that. My question was, at some point, will it have to go to county? And I think the answer is yes.
Yeah.
At what point the county wants
Alana,
to
do
see it.
you know who to call?
Yeah,
Yes.
yeah, I've talked to him before. I can call him.
Okay, good. Thank you.
Amy had her hand up.
They've been cranky. Planning board.
Amy?
Board sends them something that is not complete, so they've gotten cranky before. That's the only.
Yeah.
I know.
It's your purview. Do what you feel is proper.
No, it's point well taken.
Okay, Amy, you have a question?
Just a procedural one. Apparently, we expect a lot of comment at the public hearing. Would it be appropriate to say, please don't read a letter that you already submitted into the public record? Just give a short summary of the letter or something like that. Would that be appropriate to save time?
Yeah, well, yeah, I mean, it is within the province of the board. I mean, the board makes its own procedures. And I think, it may be something where you want to ask people who want to speak that if everything they have to say is in their written submission, the board would certainly appreciate it if they would just make that written submission, but I'm not aware of any procedure that the board has ever set down that said, put everything in writing, you can't speak.
The only problem I see with that, with having to endure listening of a letter that we as board members have all, in fairness to the applicant, they may not have received these letters. Alana, do they receive all the letters?
Yeah, so based on the conversation you had with Joe the other day, I was advised to send Kathy the comments that we got because it didn't seem fair that you guys would see them and they would not see them. So they would be listening to a conversation that they didn't really understand the context of. So I generally send public comments to applicants so that it's a level playing field.
Well, I almost believe that we should adopt that as a procedure.
What to send?
That when letters come from the public, Joe, I'm going to ask your advice on this, is that when letters come from the public, whether they are fact or fiction, they should go to the applicant. Joe?
Generally, everything that comes in that's going to be considered at the public hearing is available to everyone. Okay, so the applicant gets everything. If the applicant submits something to the board, anyone is entitled to look at it. They can request it. They can make a FOIL request, have it read in at the public hearing. See, the problem with only asking for them to submit written submissions, when you say a public hearing, the problem is if they don't read it aloud, all of the other people in attendance at the meeting have no idea what the person's position is.
Yeah, that's a good point.
See, they don't get to read. If you've put it in a letter to us, you needn't read it into the record. Well, the problem there is the other listeners then never get to hear it.
I thought all the letters were available to the public so that if you wanted to make a comment, you could look and see not only your own letter, but everybody else's letters as well.
I'm reticent. Oh, sorry, Amy, go ahead.
No, I think
I'm reticent to limit folks to written statements given language issues or what have you. If someone writes a letter, but they're more comfortable speaking in public by reading said letter, but they want it read aloud for the benefit of their peers, I'm reticent to limit. We can encourage, I would suggest that, but I wouldn't want to limit it.
Yeah, that's exactly what I'm saying. Not to forbid people from speaking however they like, but just suggesting in the interest of saving time, when somebody says, I'd like to read a letter, that perhaps it would be appropriate to say, we received your letter and we read it. All the members of the board have it, all the members of the public have it. And would you consider just letting us hear your summary of the letter?
I will say a lot of people don't believe that.
Yeah.
Based on my experience, even though I say I have forwarded those letters. I know that board members have read them, or I advise that members say, we have read your letters, or like even cite something they read in the letter to prove it. The public is still anxious that the letters aren't being read. So that seems to be a comment that I have, and a concern that I've heard before.
Excellent point.
If the speaker elects to just submit something, that's fine. But again, you really can't tell them not to, because then nobody else hears what they have to say.
Right.
Yeah, I think it's a public hearing after all, and
public hearing.
A minimum burden we have to bear to.
Yeah. Stacy?
I agree with John. Yes, it's something that you know you have to grin and bear, and you have to listen to everything, because it's only appropriate that people be able to speak how they feel, and submitting how they feel as a matter of record is easier for us. Okay, but typically a public hearing, you come out and speak. You submit the letter just as backup, and it's easier for the record.
Right.
It's also people's right to hear.
I actually lost my train of thought. That's not where I was going with that. Maybe it'll come back before the meeting ends. My apologies.
That's okay. Senior moments, we call those.
I also did make, so the public can actually read other people's letters that are submitted. So I have a system on the website where if you go look at the application that has just the materials that are supposed to be public, there's a folder that I just have the public comments in, and it just has those letters. So other people from the public can read other people's comments if they want.
Joe, what's your comment on that? You know, I'd like to believe that every word that the person reads is the word that the person printed. But you know, it's like a joke. When by the time the 20th person hears it, it's a different joke. So I'm wondering if there's any way with which we could focus in on keeping it exactly as the person stated it. I'm assuming they would ask a friend of theirs they trusted not to change any of the language. Stacy?
Oh, yeah. So going back to my thought process was that if you read your letter, okay, in public, and then it was my turn to read my letter, there could be something that you said that would trigger a thought process for me in response to the application. So that's another reason why it's important that people be able to speak in regards to application, not just send something in writing.
Okay.
Yeah. And Lynn, I think if someone is going to read a letter, whether it's their own or they've been asked to read it by someone else, I think it is important and should be required that the document that they claim that they are reading from has to be submitted to the board.
Okay. Then we would follow it.
I don't think you can say I'm reading this writing and then not submit the writing.
Okay.
Okay, I think then the writing needs to become also a part of the board's written record, not just the spoken record that we see on camera.
Now I have something embarrassing to say. I can't remember if we set the public hearing. Did we set the public hearing? We did.
March 10th.
Okay. So Stacy, you're not alone, so don't feel bad. Okay, I entertain a motion to close the meeting.
That's the motion that they're looking for.
I
move to close the meeting.
Thank you, Catherine. All those in favor, 5 aye.
Aye.
Motion carried. Good night to all, and thank you for participating. Good
Bye.
night.
Thank you all.
Good night.